Your name? All right. Where are we on this?
Your this Stone Burner did not pay her escrow. She was ordered to answer. I think she got her answer in nominally on time, but she did not pay her escrow.
Yeah, I paid $550. Yes, I did. I can't deny the other $550. It was going to be given to me, but it was not. And so I do agree with that.
$550 was paid on April 3rd, according to our records.
Order was for $1,100.
Yes. Where's the balance of that, ma'am?
Balance of $550. I was, be honest, the other occupant and stuff was supposed to have given it. He did not, and I could not come up with the money my own self. So I paid my time. I could deny it.
Yeah, they're in advice to run, Your Honor. The other occupants unauthorized. So that's part of the reason. Blatant interpretation is that she's got unauthorized occupants in the unit without permission of the landlord, and it's a violation of release.
The answer is late also, but this is a termination of tenancy case. Is that correct? Well, you haven't complied with the escrow order, and the answer was late. I'm looking at it, deciding whether or not I should strike the answer. But in any event, plaintiff is entitled to an immediate trial on the issue of possession. So are you prepared and ready to go to trial, ma'am? Pardon? You are? Okay. You have your client here, or? Okay. The basis for the termination?
Basic determination was damage caused by the unauthorized occupant flooded the house, causing several $100 of damages. Would have been more if he had done a lot of work himself. But it caused a flood above him, which caused the ceiling to collapse. It denied responsibility for it. Well, actually, what she said is talk to the other guy, the unauthorized occupant, he's responsible for it. The damage to the premises, two unauthorized occupants living with her, violation of release. Frankly, I don't think she's already admitted that the other occupant didn't pay his supposed debt escrow. So her own admissions are that she's got something else there that's a violation of release. I don't frankly think there's a threat.
And what's your position, Ms. Stoneman?
Yes, sir. Yes, Your Honor. We signed a lease back in October with Mr. Palmer, with Chad from CMH, that paid the amount and a security deposit, which Mr. Kevin Salisbury is on that. When me and Kevin Salisbury had an argument, Your Honor, I went to my landlord. He ripped it up in front of me, the original one.
The original one.
The original lease. And then we made up a new lease, which also he did not give permission to Mr. Kevin Salisbury that he was terminated. He never evicted Mr. Salisbury from the tenancy. He just ripped up the lease and had me do a new lease without consulting Mr. Kevin Salisbury about it. So that original lease should still take place, and I am also guilty with Mr.
Well, do I have a copy of that alleged?
The first lease?
Yeah.
Yes, I sat there and gave it back to Mr. Palmer, which he knew this. And,
Well, but do I have a copy of it?
No, I don't think so. Because Mr. Shad said he didn't have enough accredited time from CMH that he does have a copy of the original lease with Kevin Salisbury on it, I'm on it. And there was a verbal agreement with Mr. Palmer, knowing that my 15-year-old daughter, I worked very hard for 3 years to get sole custody of her, and he knew this. And he said we didn't have to add her because she was a 15-year-old. And
What happened with the damage to the premise?
that, sir, he called me on my phone, and I was at work.
He who?
Mr. Palmer called me, and he said there's water going upstairs. I said, well, I'm at work. Knowing that he's a landlord with a key, if he knew there was probable damage, sir, that the expensive water was running, he has permission to go into my apartment with his key to go and check on that damage. Your Honor, I have never heard of this after that. Nothing. I've never seen a bill, never seen anything. I paid my security deposit, so if he had out of pocket expenses, sir, he should have used my security deposit.
She can't do that. So why'd you sign this other lease?
Out of anger. And I went back to Mr. Palmer and I told him there, and he had no problem. Maybe I should have talked to him under different circumstances, Your Honor. Because Mr. Palmer sometimes I will not say this. I will not retire car, but Your Honor, my thing is if he had damages, I wish he would have shown me proof. But he did have access to my apartment. No, he had a key to it.
I mean, you're not claiming that there aren't damages.
I don't know if there is, or he never gave me no proof.
Who is it you say has this other lease?
I mean, Mr. Palmer. That's who I handed it to.
But you said somebody else has another copy?
Yeah, for CMH, yes, sir. And he didn't have an adequate enough time, and I've also.
What do you mean he didn't have adequate enough time?
When I went and talked to him about it, he said it's gonna take time to fill out everything, and he knew that I had court today. I put that in my written statement. I also stated that, I asked for, for him to give me proof. If he can give me proof that there was damages and that he could work on the floor, that it was flooded, he should have some kind of record of the cost of that. So if he did have that cost, then he'd be able to take it up.
So is this other individual residing in the premises?
Yes, he is. And he is willing, I think he's gonna make his own motion with Mr. Palmer.
His own what?
He's gonna be taking Mr. Palmer himself to court. Late trying to whatever, because he still legally should be able to be there with the lease that his grandmother has, or whatever he's trying to find. And my daughter, she's 15 years old, Mr. Palmer. And I'm not saying this, but normally, I mean, my daddy always said handshake is better than. And I did trust Mr. Palmer's word, and he trusted mine, and I'm guilty of, some things myself. I'm not saying that.
Was there another lease, Mr. Friedman?
In other words, Your Honor, the lease that's in place is the lease with her alone, one occupant, her. And no other occupants are authorized.
So I guess my question is a little bit more specific than that. What I hear the defendant indicating is that there was a lease that included two people. That somehow what she's basically claiming is that impermissibly that lease was terminated and this lease signed. Is that correct? Do you know?
Yes, it was.
Do I have a copy of that other lease?
It was destroyed. It was destroyed.
Yeah. Under what basis then was that lease terminated and this new one put in place?
When the man in question took her car and totaled it, I didn't see him. She said, I don't want him here because here is trespassing. Is there any way we could rewrite something so he cannot be here? So I said, are you sure? I said, give me the only sole copy of that lease. And I destroyed it. I shredded it, at least for her. So she wouldn't have to worry about this person bothering her. And then he shows up right before the holiday and said, oh, he's my guest for the holidays. Starting before Christmas and continuing until today. I mean, still there. And then 3 weeks ago.
All right, well, how long, that would not be a proper way, just on the face of it, to terminate the lease, the previous lease, and then enter into this next agreement
He had left.
and then seek to evict her for what may have been that prior agreement. I mean, there,
Well,
go ahead, Mr. Friedman.
he left and
I don't-
And so, and basically, I mean, and she's saying, I don't want him around. He's destroying my car. He's left. I don't want him around. I want a new lease. So he does, you know.
But the question is how was his interest in the property as a tenant terminated? I mean, we get into a very strange world if leases can be terminated by somebody tearing up the lease.
So he did abandon the premises.
Do you agree with that, ma'am, that he abandoned?
He did leave because he was in the hospital, Your Honor. He did total my vehicle. He was in the hospital for a week. He definitely came back, and that's when Mr. Palmer called me about the water, Your Honor. During that time, he already knew Mr. Salisbury was staying there. He knew this. How come he knew about that?
Okay, so how long did this gentleman leave for?
About 5 days in the hospital, and I do have proof.
Well, okay, so hold on. You and this other gentleman are in some type of relationship with that is the case. And so as I hear it, Mr. Palmer, something happens as a part of their relationship. She tells you, and then you tear up the other agreement and enter into this new agreement. Is that?
Yes, she said he was gone. She didn't want anything to do with him, doesn't want him there because he's trespassing. So to save her from, I don't know what kind of trouble, she said he's not coming back. She said, no, I don't want anything to do with him. I'm done. It's done. So I said, well.
Okay, so how many times have you heard that in a relationship? I mean,
I don't,
I mean,
I'm sorry, I just don't deal with it. I'm just wondering.
I know, I'm just saying,
I just,
I mean, on behalf, all parties, at some point, will tell anybody else, I don't want somebody there. I mean,
he was physically gone. He'd taken her car. He totaled her car. He was in the hospital for 5 days. The day he came back was the day she left, I guess. And when he turned the shower on, I don't know, it was running for an hour at least. I'm banging on the door, banging on the ceiling. I knew somebody was in there, so I didn't want to go just walking in there. As she said that I had keys to enter the property.
which you do.
Yes, but I didn't want to just go walking in there. I'm banging on the door. Somebody was physically in there. I didn't know what was going on. I couldn't turn the water off on my half, so.
Yes.
So then. I'm not even clear what to do with this because I've got this other lease that sounds to me like it's not properly terminated.
Doesn't exist anymore.
Well, Your Honor, it seems to me though that the only person that would have any standing to raise that issue would be the dude, whatever. And he's not here.
Well, no, the defendant has standing to raise the issue because if part of the reason you're terminating her or the basis for the termination is that she has this unauthorized occupant. And then two unauthorized occupants, who's the other one?
Her daughter.
Oh, for,
He's taking, we did do a verbal agreement, Mr. Palmer, when I did it.
how old's your daughter?
She's 15.
So you're claiming that's an unauthorized occupant?
She didn't have, she didn't have the daughter when she signed the lease. She was in custody.
And now you have custody.
Yes, so after 3 years, I got custody. Mr. Palmer knew.
So what am I to do with this daughter?
But
I mean, am I supposed to tell her, her mother, oh yeah, you fought for custody of your daughter, but she can't stay there with you and your lease is being terminated. So I'm now, because you fought for custody of your daughter, you're now going to be homeless. Is that what I mean, is that the position that plaintiff is taking?
that's not the position plaintiff's taking. We're saying is that when you add it all up, there was supposed to be one occupant, and now there's three.
Well, no, because Miss Salisbury, the other lease, there were two occupants. And so so maybe there's three now. And then I'd have to figure out what to do with, I guess, this newfound daughter. And then
Then there's another 800-pound girl in the room, which is there hasn't been any rent paid since January.
They partial rent in January 800 at 1150, and there hasn't been any payment for February to March, which is the tune of $4,400.
go ahead.
With the damages and stuff, also that he's trying to terminate my original termination. Is, he never forthcome. When he called me, I was at work. He talked to me about the water. I said, Mr. Palmer, I'm sorry, I am at work. And he says, okay. I called back again within a couple of hours and it was off taxi. And that is the last time I heard from Mr. Palmer on the issue of any damages. Never seen a piece of paper, never seen any damages.
Do I have anything about the damages, since everybody wants to go there? I mean, I'm still stuck on this lease thing. So you have a copy? Go ahead, take a look at it, ma'am.
I did not see this is the first time I've ever seen.
No, I know, but take a look at it. Do you have any objection to the court seeing that?
No, let me see.
Well, hold on. Do you have any objection to me looking at it? Because I don't know what you start talking and I don't know what you're talking about. Okay, so.
Contractor?
Okay, does the contractor, does the contractor have a name?
Yes, Jeremy.
We have the photos of the damage. Let's see.
No, I understand that, but
Rather ask people one more time.
no, not right now. Sometimes it's better not when you're ahead. So it's $625.
Yes, sir.
Okay, but have you paid this?
Yes, I have.
Is there a receipt for the payment?
I didn't get one from him, but I just paid him cash, gave you that as a receipt. As it says there, paid the final amount.
By somebody who it doesn't. Okay.
If you see the pictures, you'll see the 625 as a parking.
Okay, I don't. Here's the problem that I see. first thing is this other lease. Because I don't know if this other lease is the same as this lease, but just the names change, or if there's something different in it. I don't know that. That's the first thing. Second thing is I am still unclear as to how he, in essence, terminated a tenancy by tearing a document. Because the reality of what he did would not only be to terminate the tenancy of the other individual, it actually terminated her tenancy, and then she enters into a new tenancy, supposedly. But I don't know that that first tenancy was properly terminated. If it's not properly terminated, there's at least an argument that this lease that you're seeking to terminate her is void or voidable, and that other lease is the one that applies. All right, that's my just initial thought on this.
Certain.
Go for it.
I
I don't know why you were involved in their relationship. So go ahead and you tell me what you want to tell me.
I was not at all. I thought, by the way things have went for her, and she was coming to me and saying, hey, I don't want him here. Basically scared of him. I don't know what the situation was. If he's here, he's trespassing. Can we do this? Her and I stood there, and that's what we agreed to do the new lease.
I wonder if I could have done that with my mortgage company in Maxwell. Could I? I mean, I'm just asking. I mean, if stuff works that way. Alan? Okay, all right, I'm just checking.
I think this is the thing where he thought he was doing her a favor and.
I know, but I get that. Good Samaritan and all that wonderful stuff. But then I'm now here, and because this guy came back that she may have been mad at him for a while. They patch their differences. I don't know, her car gets repaired, whatever. And then because she does that, and because there's this damage, I get the damage part, but because she does that, the one basis upon which now she's being terminated, it seems, is because she repaired her relationship, and also is being terminated, I guess, because she was successful in fighting for custody of her daughter. This is a beautiful scenario.
Well, we didn't raise the daughter issue, but it's.
Well, no, he did. I mean, so let me ask this, Mr. Friedman. Is part of the basis for this other person her daughter? Part of the basis is that she has unauthorized occupants. Is your client claiming that the daughter, the minor child?
We didn't mention the daughter.
Okay, so is that an issue?
We're not raising it. It's a fact.
Well, he did. Okay, but when I said there's an unauthorized occupant, somebody said two. And so one of those would be her daughter. So what I'm asking is part of the claim in this case the daughter in the premises?
No. It's a fact, but it's not, we wouldn't have terminated the tenancy because of that. No. We terminated.
Okay, so I don't have to worry about the daughter.
No.
Okay.
But
I just have to worry about this guy that she got mad at, that all of a sudden the lease gets torn up, that then they repair their relationship, and now he's an unauthorized occupant. That's the only one I have to worry about.
And the fact that he caused the damage, yeah.
Okay, I mean, we can get to the damage part, but and what?
They haven't paid rent since January.
Okay, but I've got a termination case
I
in front of me.
understand, but you're gonna have, it's a 7-day case in 8 days.
Okay, so, ma'am, the individual that has a copy of this initial lease, How long did they say that would take them to get?
Which had until they come tomorrow and we'll figure it out. And what happens. I did propose to Mr. Palmer through Ms. Jill, that I would like to be out by May 31st. I'm willing to give the security deposit by 50, and I'm also willing to pay the first month's rent in May by the first of $1,100. I would like to be out by May 31st.
So you want to pay $1,100. He keeps the security deposit. You don't have any claim over it. And you just want to be there till May 31st. Well, hold on. Yeah, there could be an immediate trial. However, I've started a trial, I guess, but I've got an issue because of this other lease. So, and it's not here because your client says it's destroyed. She says there's a copy that exists, but she can't access it at this point. She's going to try to access it today. So it would seem to me that I would adjourn this in any event.
I understand. This is my first trial. My first time in front of you.
I know. Yeah, I know. You can see where it's going.
But I would say this, if I was inclined to make that suggestion, I would want a COD because that would
And I think that could be in a COD. She seems very definite that she's going to do these things and then leave. I don't think your client likes the idea. So why don't I just adjourn the trial? And my next date isn't until like late April anyway. Huh?
April 22nd.
So it would be April 22nd. We'd have a trial. I don't know. I don't know how long it would last. We might get till the end of May in any event. But I mean, if that's her proposal, it seems like a reasonable one. She doesn't want to stay. And by the way, the other thing that's faced is that if I find that the lease here is void and or voidable, you're going to lose anyway. Once I see that second lease. Or at least there's the potential. So here's what I'll do. You're going to get a copy of that other lease. I'll adjourn the non-jury trial to April 22nd, 2025 at
9 a.m.
9 a.m. And something we've learned today. If your lovely wife starts yelling at you, just give her a notice to quit. All right.
I do want to use the request for escrow. Give it back.
I understand, and that would be my next available date for a trial. So you're entitled to an immediate trial, and she's gonna pay her escrow. Bye. I guess she's leaving. Okay. All right. Thank you. No, really? I hear that. Sycamore Meadows versus Caleb E. Wow.
That was next, Judge.
Yeah, I know. That's okay.
Attorney Carrie Zannon, P67390 on behalf of Lincoln.
Just hoping her husband's now watching.
Attorney Jill Bauer, P69260 on behalf of Ms. P.
P is present.
Caleb E.
Thank you.
Judge, we adjourned to see if I would have authorization, and I do not. So we are stuck to having to go to trial. So we set a trial date.
And I did, just to let the court know, I did find an entity that was willing to pay for an electric stove and for the electric hookup.
And I'm not disputing that. I'm just
Yeah,
telling you, at this point, I don't have the authorization to agree to it. I will work on it. And I told that to Ms. Bauer. I will continue to work on it. So if we could have a trial date. I know that your next date is the 22nd, and I apologize, but I'm actually in a conference.
Okay, that's fine. We can. After that day. Oh, right. Because that next week that I would have in the first part of May, everything gets combobbled with my calendar because of a judicial conference. So May what? Set non-jury trial in this matter for May 20th, 2025.
Your Honor, we did have a jury demand.
And we have motions pending too, so on May 20th, if you want to hear our motions, we can do that, Judge.
All right, here's what I'll do. I'll do the motion that I'll set jury final settlement conference. I mean, I could set it for this Friday. Would you be ready to go Monday?
Jury trial.
Oh, yeah.
If we had to, it would be my first choice. We do have the motions pending.
We do. There's,
Yeah, but I can rule on those on day of trial. Can I?
no, I don't think that you can rule on those on the day of trial. I think mine you could.
I don't know that you can
I think on mine.
because I'm not smart enough. I get you. No, I hear you. That's okay. I'm not going to take offense.
June 6th and June 9th.
Jury final settlement conference, June 6, 2025 at 9 a.m. Jury selection if necessary, June 9th, 2025 at 8:30. Those are in-person proceedings. I would indicate that because this is a civil matter, it may give way to any criminal cases. Thank you.
Thank you. Okay.
Evergreen Apartments versus Matthew Chavez.
Good morning, Your Honor. Melissa Gazari for plaintiff.
Hello, your name? Okay. Where are we on this case?
Your Honor, the outstanding balance is $1,840.61, which involves a request that Mr. Chavez made for an ESA. Plaintiff has been trying to work with Mr. Chavez regarding that request, and we need updated shot records for the dog. I did have a chance to speak with Mr. Chavez. He indicated that his Avalon caseworker was bringing that information. And the information that was provided was the same thing previously as from 2020. We need
Those are the most updated shot
updated.
records we had.
So we're here that the dog does not have updated shot records. And I will also state that in late March, it was discovered that in addition to the dog, there's also an unregistered cat in the home as well, with no vaccination records or details on that either.
Okay. So let me ask this, Ms. Kazari, if there were updated records, does something happen to the balance in this case or?
So I don't know if they're willing to retroactively go back and make any changes. I know.
Right, but certainly at this point, they're not because there aren't any updated anything.
Well, I wouldn't think that it would even matter because according to the FHA, it doesn't allow landlords to deny on the basis of rabies vaccination boosters or any pet-related.
So for there to be an animal in the.
Yeah.
It has to be registered and it needs to have.
It-
it needs to comply with public health.
Okay, let me ask you this.
But it doesn't, I mean, are they saying that what am I trying to say? It's like a dangerous animal?
No, well, all right.
Because as far as I understand, that's the only way that they can deny an ESA is if they're trying to say that it's dangerous, but if they're charging me it's not dangerous then?
No, but they can put reasonable requirements on that.
I understand
Okay,
that,
so
but
no, and that,
charging for this thing is not an ESA.
no, but if you're not complying with what their requirements are, you can be charged. So, Mr. Chavez, let me try to understand what's your fight about on this? I mean, I think it was an ESA at some point, correct?
It definitely, I mean, it is. I've given.
Okay, but hold on. Let's assume that that's the case.
Okay.
The animals still have to be, they have to have the vet records that the animal has its shots. So
They do have it.
they have them from 2000, what is it, 2020. That's 5 years. Okay, so let me ask you this. Has the dog and or cat, have they been to the vet?
Not since, not since I've been. No.
Okay. So, Mr. Chavez, it seems the simplest way to try to resolve this, okay, would be for you to get the animals to the vet to get their shot.
Yeah, I mean, that's fine. I can do that. I have to find a way to fund that, but I mean, that's not the problem.
All right, do you know what shots they're missing? I haven't had, well, if it's 5 years, pardon?
Rabies booster?
They're missing the boosters. I'm sorry, ma'am.
Rabies booster is what was specified in the email.
Okay, so it doesn't have the rabies booster and all the other shots may be.
No, they should.
The other shots are there.
I mean, I would have thought that I would have gotten some sort of notice from his vet if he was late on some sort of booster. I mean, I would have assumed that the case. I didn't think I thought that they were just asking for something they already had to try to keep charging. Basically.
No, here's what I don't. My impression is that they don't want to just keep charging you, but they also. Let's approach it another way. Let's say if for whatever reason, even if your dog was thinking that somebody was doing something to you and the dog bit somebody, right? There's going to be a whole lot of other problems if those rabies shots aren't up to date.
That's understandable.
Okay.
Okay.
So if you understand that, you can understand why the landlord really wants that to happen.
Oh, I can understand that. That's not how they brought it to me. They just told me.
Okay, Mr. Chavez. Mr. Chavez, you need to get off of that.
Okay.
I need updated.
That's fine.
You can sit here and fight about this all you want. I just got to figure out. Okay, I got it.
Chavez does have his CNH caseworker working with him on getting his shots done and up to date through the Huron Valley Humane Society.
That's what I was gonna. That's exactly what I was gonna suggest.
Yeah.
How soon do
They're
we
working
think?
on it. They're trying to see when they can get them in. And so this was brought to a CNH worker probably about 2 weeks ago after the last court date. It's like, we need to get him up to date because I reached out to Evergreen and gotten a copy of the shot records to look at them myself. So then I
Got it. So then you could try to figure out. Okay.
Exactly. And his other issue was just how long it was taking them to get back with us. It took probably about 2 months for them to get back, for Evergreen to get back with me and let them know that it was gonna be
us at
denied.
all. And meanwhile, they're just
He was
charging.
concerned about that.
Okay.
So
Well, I'll deal with the. So we'll find a way to deal with the money aspect because the money aspect isn't going to matter if we don't get these shots.
Okay.
Okay. So is there any way to know if the Humane Society can get them in the next 2 weeks?
Maybe I'd have to email her to find out. I did email her last Friday and ask if there was any updates, but I haven't heard back yet. So we could probably do some chasing today maybe stop up there and find out if she's heard back
Can
from the
Amy,
community
in here for
side
me.
or stop up there.
Hang on, I'll figure something out. Yeah.
Okay, so we can stop up there too. I've got the whole day slotted out for Mr. Chavez. But I would like to know, because I'm doing the requests for the financial assistance for him. So that has been a part of a big problem. I did ask if it was going to be prorated from the time that he sent in the ESA letter. I don't think it's going to be though, just because of the fact. that-
You mean the amount of monies?
Yeah.
Okay,
So
so,
I'm just gonna start
folks-
from this
Okay.
point.
right, but the first thing that has to happen is we've got to get this shot. Right? And then the money, you know. that. All right. Here's what I'm gonna do. I'm gonna pass the matter briefly. We're gonna make a call, see if we can get this dog in, get the booster. All right. Pardon? What?
It's like they help with hand vaccinations for.
They're charity for a moment.
Okay, but hang on. This dog just needs a rabies shot. Okay, that's what I'm trying to find.
Your Honor, for clarification, I'm not clear on what shots are needed, just that it's not up to date.
Okay,
I have the records that Ms. Suarez just provided to me.
okay, and it has distemper, it has all of those other things. It's just the booster on the rabies.
The email I got.
That's all anybody
I
said.
didn't-
From the email you got from whom?
Joseph Humes.
Who is who?
Evergreen.
He is an evergreen, she didn't really say.
He's a property manager.
Okay, and he just said it needs the rabies booster.
Specifically rabies vaccination.
Okay, all right. Then if that's what they say, let's see if we can get it done. All right, so have a seat and then I should know momentarily if we can get you in.
Okay, perfect. Thank you, Your Honor.
You don't have anything about cat.
Yeah, I have a cat. I don't know what that came from.
You know,
My girlfriend brings her cat over once in a while, but that's not, so it doesn't stay there. It's not there very often. It's not my cat and it's not there now. It's not there often enough to be called living.
okay.
Yeah, that's actually meant to address that.
So
So,
I think you can't have the cat property.
okay, well.
Yeah, that's gonna be
That's fine.
what? Yeah, the cat can't come over. All right, just, you'll have to tell the cat. All right. Okay, court does call the case. R&J Group Holdings versus Saffield. I guess Saffield.
Anthony Molina appearing on behalf of R&J Holdings, Lane.
This is Dr. Lazar Stefan, on behalf of myself.
All right. Have the parties tried to talk at all or no? Are we gonna go to trial?
No, there's no talking, unfortunately. in this case. I'd be willing if the court would direct us to, but I don't think there's anything we can discuss. It's a termination of tenancy case. Talk about it.
Your Honor, I'm open to talks and the communication is not a strategy, but this is not a tenancy termination. This is a purchase agreement, the subsequent tenancy we signed this exhibit G with this gentleman's clients. And it's dated November 17 of 2024. Signed the purchase agreement. We want this to be enforced as a matter of fact.
Yeah, but I can't enforce the purchase agreement. You've been to other courts to enforce that purchase agreement, correct? Then what was the complaint in federal court?
Court case, Your Honor, is a wrongful foreclosure suit against Wells Fargo that subsequently we added and amended the complaint and added R&J to that case. That's why. we filed
And
the
then
motion.
that case, did he give you?
Yeah, I just need contact information and information and then call back. He could see me during today.
Ah, wonderful. Hold on. Where did Mr. Chavez go? I'm gonna break in this case, recall, Evergreen versus Chavez. I need, you, what do we need? We need,
I need contact information for Mr. Chavez and then just some general information about
the dog, and then they can see you.
They can see me when you're done.
No, if they, once that happens,
I will call back the Humane Society and they could see them sometime this afternoon, tomorrow, depending on your availability. They'll make it happen.
it could be today.
Okay, yes, sir.
Because he got somebody with him. So, okay. So we'll get that information. She'll come out, get that information from you. I'll adjourn this matter out to my next date, which is April 22nd, 2025 at 9 a.m. Okay?
Your Honor, can I?
Yes.
One thing I would say is if potentially, Mr. Chavez's caseworker could maybe help him apply for mental assistance in the meantime as well.
Yes.
Yeah, I think they were working on that piece also, but we weren't going to get anywhere until the dog got his shots.
Yeah.
So,
Okay.
okay. All right, great.
Oh, that's-
All right, so get all of that and then we'll. And do you have copies of the previous? Make sure to have with him a copy of the previous vet records to take with him down there. Okay, so that, all right, we'll get it taken care of today. Thank you, folks. All right, we're back on the our R&J Group Holdings. All right, the question. You added R&J to the federal case, correct?
Correct.
And then that case was dismissed.
It was not.
Okay, is it pending?
Yes.
And did you get a stay of these proceedings in federal court?
I didn't petition for a stay in federal court. I'm petitioning to this court for a stay, Your Honor.
That stay is denied. I'm not issuing a stay. So, ma'am, I'm trying to figure out what's your claim. Because I read through everything that you filed before the court, much of it, which was also stricken, but then you filed other things. You haven't complied with that. As to the issue of possession, I don't see that there's an issue for me to try.
Issue of possession is a non-issue. First of all, according to the lease, the court that has jurisdiction, we agreed on that, is the Circuit Court of Oakland County on section 13 of the lease. Excuse me.
I don't think you can't confer jurisdiction that way.
Well, they have
What?
They have put in that lease agreement that in case of conflict, we have to go to Oakland County Circuit Court.
Yes, but the property resides in Washington.
Correct, I agree with you.
Then venue and jurisdiction is here.
Correct.
Hey, you can't do it that way. Even if that was agreed to, it's unenforceable.
I agree.
Okay, so we're here. so everybody doesn't have to head to Oakland County. Might make my day easier if you would, but you can't. Okay, so, it's here, and so when I look at everything, I don't see as to these two parties that there's anything for me to try, that they're entitled to possession of the premises.
Despite the purchase agreement they signed?
The purchase agreement, you're making that part of, did you file an action in circuit court regarding the purchase agreement?
I'm intending to do that.
But you haven't. And they're saying you defaulted on the purchase agreement.
You're wrong.
Okay. But if you're seeking to enforce the purchase of the property, can't do that here.
The lease agreement has a provision that within a year, we are entitled to purchase the property. That's what we're trying to do. To buy the
Okay,
property.
have you purchased it?
We secured the loan. We ordered the title work. The title work shows that there is a lien on the property and the mortgage company would not issue any loans to me unless the lien is removed by Mr. Molina's client.
Sir, what's your position on this?
That's simply not true, Your Honor. There were two liens on the property. One of them was a mortgage lien that's paid at closing.
Right.
Proceeds to sale. The other was a lien that was placed on the property by the homeowners association by virtue of her actions while she was in the property before. That aside, we did obtain title commitment, guaranteeing her clear title at the closing. And I've got documentation and we submitted that to her mortgage agent and her prior to the date the closing had to occur. So that's simply not a true statement.
And the closing hasn't occurred.
No.
We submitted the documents that they gave us to our mortgage person and to the title company, and neither one of them
So
accepted.
let me ask you this. Are you going to let her buy the property or do you want it back?
Today, we want it back. If she wants to negotiate or buy it later, that's fine with us. We're not opposed to her having the property. What we're opposed to is her staying in it for free subsequent to the chronological termination of the lease. So my client does want it back, and I'm not sure at this point whether he wants to sell it to her, but I shouldn't say that he does. But there's nothing personal here. We just want our property back because we're entitled legally to it. And there was no breach on our side of the purchase agreement, period, in our opinion. I have documentation.
No, I looked at everything. I don't see any breach regarding the purchase agreement. It's just.
Yes, there is, Your Honor. May I speak?
Well, why haven't you brought an action for the breach of the purchase agreement?
Because they brought an action for possession. I'm busy responding to that.
Go ahead. What do you want to say? What do you want to say?
I'm sorry.
What do you want to say?
What I want to say is the gentleman's statement is absolutely incorrect. We have paid money to run the title, and since they purchased the property, they are the violator of the lease agreement because they were not supposed to get a mortgage on this property. They have. Also, there is a fee on the property that prevents us from going forward with the purchase of the property because of the lien. And the lien is not removed. And it happened when they own the property, not we own the property.
The lease has expired.
The lease has expired, but the.
And then, but hold on, ma'am. The lease has expired. You're seeking to enforce this purchase agreement.
Correct.
That's not done here. That's why I'm saying I don't have a tribal issue. The lease has expired. They filed proper notice. They're entitled to possession of the premises. If you wish then to enforce your rights regarding that purchase agreement, that's going to have to be filed in another court.
Okay.
I mean, I think it's as simple as that. Is there anything else you want to tell me?
So I'm here today fighting for my, this is my primary residence. They promised they're gonna sell it to me. They are backing up from their promise. They broke every single provision in that.
Okay,
agreement.
ma'am, you can tell me that all day and night long.
That's fine.
And the problem is that has to be heard someplace else. It can't be heard here because the lease expired. They're seeking possession of the premises. So court after hearing finding no tribal issue, granted judgment for possession to the plaintiff. There is no redemption amount per se. What I will do, ma'am, is normally a writ would issue in 10 days, but you can I'll indicate that a writ may issue April 30th. Then if you wish to file some action or seek a stay, you can do whatever you want to do, but I'm going to have a writ issue April 30th.
Also, I put a $5,000 in escrow and that be released
To whom?
to myself.
If I may briefly.
You could say, go ahead.
Rent is due prior to the end of the termination of the lease, so we're not accepting any rent for periods after the expiration. So I believe my client's entitled to that.
I beg the difference, Your Honor. They are saying that lease was terminated as of November 1st, and I paid the October payment. So as of November 1st, they are not entitled. If they claim this lease is void and null. Excuse me.
You guys done? 'Cause here's what I'm going to do. I'm going to issue the judgment.
Okay.
Okay. Writ date of April 30th. I'll set a hearing on the release of escrow for May 20th, 2025, after I see where the landscape is. All right.
Thank you, Your Honor.
Same
God
10-day
bless you,
appeal
Your Honor.
period. Same 10-day appeal period. And then,
On the judgment, you mean? Yes. Correct.
thank you.
Thank you.
I'll prepare this to go to you.
All right. Thank you, sir. You guys do the same. Thank you.